Your medical malpractice case is going all the way to trial. Finally, after 2 years of hard-fought litigation, now it's time for your trial to begin. And you want to know, does the jury ever learn whether you have had settlement discussions with the defense, and if so, how much money has been offered? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, the jury is never told about any settlement discussions. And if settlement discussions have gone on, then guess what? The jury is never told the details of exactly what happened. Now, why is that? I'll tell you why. If the jury understands that now settlement discussions have gone on, they certainly are going to be curious. They will certainly want to know why settlement negotiations have not concluded and why they're busy wasting their time sitting in court listening to a trial if settlement discussions have gone on. And if you're so close, why haven't you settled this case? There are lots of reasons why we don't tell the jury whether or not settlement discussions have gone on. The entire purpose of why we have a jury trial is because the litigants, the people who are bringing the lawsuit and the people who are being sued, have been unable to resolve their dispute before reaching the trial. And now we need a jury of 6 people who have told us from the community, who have told us that they can be fair and impartial, that guess what? Hey, listen, we need your help. We need your help to solve a problem. What's the problem? We believe that the doctor was careless and that his carelessness caused my client harm and injury. And now, if you find that to be true, now you have to determine how much money she's entitled to receive as compensation for all of the harms and damages and losses that were caused by this careless doctor. That's what we need the jury to resolve. Maybe we're able to show, yes, this doctor was careless, and maybe the defense actually agrees with that. But we can't agree on the actual value of my client's injuries. So now we go to the jury. We want the jury to actually evaluate this. If the jury learns during the course of jury selection or during the trial itself that settlement discussions have taken place and money has been offered and money has been rejected, that may be grounds to go ahead for a mistrial and to tell the judge, listen, judge, the jury is now prejudiced, and now their thinking is going to be prejudiced because when we finish this trial, I guarantee you in the minds of the jury, they may be thinking, hey, wait a second, why haven't they been able to settle this case? How much money was offered? How much money was rejected? I don't understand. Now, the jury is going to get thrown off track. Why? Because they've heard something about settlement discussions. Now, the reality is that many people going into a jury trial, jurors sitting on this case, evaluating the issues in the case, many of them know that these cases often get settled. But we are not permitted to explain to the jury anything about any settlement discussions that took place, why settlement discussions have not concluded, why we have not been able to resolve this actual case. All of that is immaterial. The jury is there for one purpose only, to evaluate the facts in this case. They are the fact finders. Remember, we have disputes. One person says one thing, another one says another. We claim the doctor was careless because of all the things that he did or didn't do. The doctor says, no, I wasn't careless. We bring in various witnesses and evidence to confirm and to support our case. The defense does just the opposite. And now the jury has to evaluate for themselves which set of facts they believe, which set of facts are more likely true than not true. And based upon their factual conclusions, now they will go ahead and reach a verdict. That is the entire function of the jury. The jury is not there to consider whether or not settlement discussions have gone on, whether or not one side or the other should get a verdict in their favor based upon what they heard about settlement conversations that took place before the trial or even during the trial. That's got nothing to do with what the jury's function is. The jury is there to simply evaluate the facts in this case and to decide who is more credible, who is more believable. Why do I share this information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I understand you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a case and are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.